Sir. Thank you, gentlemen.
The next witness is Kevin McKeown on behalf of the Fred Getz Trust. Mr. Getz, 5 minutes. Thank you very much. Go right ahead.
First of all, Senator, my name is
Mr. McKeown. I'm sorry, Mr.
My name is
McKeown.
Kevin McKeown, and I'm not reading a statement on behalf of the Fred Getz Trust. That is going to be submitted at the subsequent hearing when those 13 people will fly in from around the country to testify before your great committee. I am here to read a 30-second statement of my own,
Perfect.
and then
I like 30 seconds.
And then I will torture you, and then I will read a short letter from a former judge of this state.
No. We don't have, you didn't submit any testimony to us, did you?
Yes, I did.
Okay. I guess we do have it somewhere here. Okay.
Again, my name is Kevin McKeown. I'm the proud member of various organizations focusing on the restoration of the trust the public should have in the judicial branch of our government. The organizations include Integrity in the Courts, Expose Corrupt Courts, and the Frank Brady Organization. I believe the statewide attorney and judicial ethics oversight structure is corrupt, and I applaud this committee for what can only be described as a heroic and beginning step in returning a lost faith by the public in this state court system. I will say one thing today as I defer my own personal experience to the next hearing to be held in New York City. The idea of having attorneys regulating attorneys and attorney judges is laughable. And today marks...
Hey, this is the last time I'm going to ask. We're trying to conduct an orderly hearing here and trying to get everybody's testimony there. If this continues, I will definitely cut it short and just end it. Okay? Thank you.
Senators, today marks the beginning of a process in which the public, attorneys, court employees, and in fact, judges can have faith that the respect that they should have in the integrity of their courts will once again return to this great state. I'm going to now read a short letter that was prepared. Judge Philip Rogers could not be here today. He had broken ribs. However, Judge Rogers was one of 3 judges of New York State that accompanied me before a U.S. House subcommittee on the Judiciary a few months ago as it pertains to the federal crimes we allege that are ongoing within the New York State court system.
Could you paraphrase it? And I mean, not read it.
It's very short, and,
Okay.
and it's done to be read, Senator, if I
Okay.
may. Dear Senator Sampson, I am a 70-year-old former attorney and village justice who practiced law in the state of New York from October 16, 1968, until being unjustly disbarred on May 31, 1999. I was the victim of a secret and corrupt grievance process that lacks the most elementary due process constraints and safeguards, and was used as part of a conspiracy by former business partners to ruin me after our venture went bankrupt. I respectfully ask that this committee propose legislation that will protect victims such as myself from suffering the loss of their law license, and as in my case, all of their life choices, as the result of a totally corrupt attorney disciplinary process managed and controlled by money, favoritism, and cronyism. By way of background, I practiced law in my home village of Patchogue in Suffolk County for 30 years of my professional life. From 1970 to 1994, I also served as the Patchogue Village Justice. I was elected to 6 consecutive 4-year terms by substantial majorities in each election by the people, who knew me best from my days as a Patchogue student. I served as the chairman of the Patchogue Medford School Board Ethics Committee, president of the Suffolk County Magistrates Association, and as a director of the Suffolk County Magistrates Association. In the end, however, my professional standing was left in ruins, and my status as a member of the bar was taken from me by a corrupt secret, non-transparent disciplinary system that places power in attorneys to supervise their fellow lawyers. Are we to believe that attorney supervision is too complex, complicated, or problematical to be left to non-attorneys? Only lawyers drafting the laws and regulations could foster such a ridiculous concept. What we have had for years now is a fatally flawed system where no one truly watches the watchers who, according to testimony of former and current staff, regularly abuses the process they are paid to administer. Clearly, the lawyer-controlled disciplinary committees must be replaced by a new system where non-attorneys who are fully familiar with ethical problem-solving review and adjudicate complaints concerning lawyer conduct. No lawyer can or should be permitted to sit in judgment of a fellow attorney. In my case, people seeking to bring pressure on me as a result of a failed business venture sought to use the grievance process to coerce a settlement payment from me, and in the end, as they themselves said on more than one occasion, ruin me. My former partners and their allies achieved their goal by using political and other connections to move my disbarment proceedings from Patchogue to Brooklyn. Once removed to this location, exculpatory evidence was ignored, perjured testimony was accepted as true, basic due process protections were denied me, and false and fraudulent accusations became the foundation of the ruling against me. When my investigation was moved to Brooklyn, I was warned that the fix was in, and later events proved this to be true. I believe I would still be serving the legal community as an attorney had the ethics process that was used against me simply been more transparent. Instead, a secreted and corrupted process intent on only ruining me ended my life of public service. Transparency would have provided me the opportunity to reveal the perjurious testimony allowed against me. It was also improper that my most basic right of due process was denied, thus preventing the vital testimony of various witnesses. Senator Sampson, I commend you and your committee for holding these important hearings on the attorney grievance process. Based on my personal knowledge of other cases similar to mine, I know that the most elementary inquiry by this committee will find that many others, both attorneys and clients, have been wronged like me. I trust that these injustices will see the light of day and permit the immediate reinstatement of attorneys wrongly disbarred. I am also hopeful that needed changes will include system-wide transparency and the providing of due process to those accused.
Mr. McKeown, we have the letter here, and definitely there's only one paragraph left, but as you heard earlier from Mr. Gold and also Mr. Friedberg, these process under law have to be done in those certain circumstances, you know. So I mean,
if I may address that, Senator Sampson, I have the pleasure of actually having personal interaction, so I'm waiving confidentiality. I have personal interaction with Mr. Friedberg and with Mr. Gold. I presented evidence that I was threatened by Mr. Friedberg, and although I was called in by the U.S. Attorney's Office and the FBI and the referral in Washington, D.C. to the United States Justice Department, although they all found it very interesting and are currently looking at it, Mr. Friedberg and Mr. Reardon and Mr. Gold have done what they have summarily done, and that is get rid of it. Senator Sampson, the documentation, I assert, is there, and I will tell you that at your next hearing, as a member of the various organizations, we will present to you at your New York City hearing over 100 documented cases of the most ludicrous and slipshod investigations resulting in what we believe is a gross pattern of misconduct by the ethics committees themselves.
I mean, that's something we're interested in. We have Senator DeFrancisco has a couple questions for you.
Who do you represent?
Myself. and the three organizations that I mentioned.
Okay, when you're talking about the FBI and the U.S. Attorney and all that, was that about a personal file pertaining to you, or is it taught for this judge that you read the letter for? I'm trying to figure out.
Well, actually, that judge had nothing to do with the FBI. However, I will tell you, when I was called into the FBI at 26 Federal Plaza, we had become a lightning rod for literally the worldwide collection of people that have been harmed by these so-called ethics committees. And they asked me to bring in my 4 outrageous cases. And I went in there. Now, before a group of us, which includes former federal prosecutors, attorneys, etc., we would go through the evidence before we presented it to the FBI. We went out, pulled case studies, whether it was a judge, a lawyer, a disbarred lawyer, or a litigant. We would pull the case files and see for ourselves what the documentation said. Based on that, the FBI asked for 4 specific, the 4 worst cases. And then in other circumstances where the U.S. Attorney's Office, where certain information has come to light, where they had then said, we want to interview those people.
I'm totally confused. I just asked you, the cases that you went to the FBI about, were those personal cases that you were called in on, or were they people you were representing that somehow got into the federal criminal system?
They were the organizations that I'm a member of. To answer your question, as a member of that organization, we brought those cases, when asked, to these federal entities.
All right, so you weren't brought into the FBI. You were seeking the FBI to look into these. Is that what you're saying?
Well, the U.S. Attorney's Office called us. The FBI, in one instance, we called them. In another instance, they called us. And actually, there's a new inquiry in another.
So this wasn't something this is something you wanted to have done to explain all this to the federal investigators, the U.S. Attorney, and the like, correct?
Absolutely.
Okay. In addition, last point, I think, you had indicated that it should not be attorneys who are reviewing these particular cases. There should be lay people. And the lay people would then make determinations concerning fraud, concerning due process, concerning whatever it may be. How would they gain the expertise in those areas as to what the disciplinary rules are and the like? Would they have to have any qualifications that you would presume that attorneys would have?
Senator, that's a very good question. And of
That's
course,
why I asked it.
They would have to be guided by what the laws are, what the procedures are. I ask you, do we want bankers self-regulating? That doesn't work. Do we want Wall Street self-regulating? We know that doesn't work.
But what you're saying is basically, lawyers can't regulate attorneys. I mean, you have very reputable and ethical attorneys who we put in these positions to make that decision. It might be an aberration here or there, but I don't see it as a problem having a panel of attorneys, and based upon their background and everything else, making decisions such as that. But if there is, as you're saying, when you present cases to me where I see discrepancies and issues, that's why we're having this hearing, so we can get to the bottom line of these things, all these allegations and these conspiracy issues. We want to get to the bottom line, and that's why we're asking for, in specific instances, so we can look for ourselves and, based upon those recommendations, make a determination.
Absolutely, Senator, and again, that is a very good point. And obviously you need attorney input because attorneys are versed on the law. But it brings up the bigger issue of people self-regulating.
Understood.
If an attorney is named John Doe, and he has been convicted of a federal crime and goes to federal prison and does time, will he get his law license back? That's a question. Of course, we all know that there was a chief judge of this state who was convicted of a federal crime, who went to federal prison and got his law license back. What this comes down to, Senator, is equality.
Understood.
And I would much rather handle a complaint that said the person's name was John Doe rather than a certain person who that name triggers favoritism and unequal treatment. That's what it all comes down to.
No, but Senator Perkins.
So do you believe that there is favoritism and in the process that, as was pointed out by the speaker before you, that do you think that those who are big shots or who have connections or some other such credentials are getting